going to proceed with that matter. We have a Monroe Circuit Court case that we're supposed to take a plea on. Mr. Bell is supposed to be here. Attorney Bell is supposed to be on Zoom. We haven't been able to get from the detention center. Have you had an opportunity to consult with your client?
Yes, Judge.
We were with him today, but yes.
For Mr. Bell, we're gonna have to come back to you, okay? We
Yes,
don't have
sir.
your client on. Maybe finish lunch by then. Oh, thank you. Now, we have two motions. Pardon? Yeah, be all right, just have. Okay, now you need to. Come over here. You're taking the hand, that's all. So somebody needs to be back there. Hold on. Where's the sheriff? He's on. Okay, there was a motion to exclude and then a motion to suppress. Is that correct?
Yes, Judge.
Is there any other motions besides that?
Not today.
Okay, I am familiar with these motions. I've read the documents and read what was there. Now, the motion to exclude certain DNA tests was predicated on the consumption of all of the DNA from the swabs that were submitted. Is that correct?
That's correct.
One of y'all want to come up here to the podium, Mr. Stockton can stand over there, and that way both of you can be behind the microphone. So are you going to take factual testimony about that, or
If necessary, Your Honor, the way I read the motion is they're wanting to exclude the DNA because it was consumed, and there's a statute says that there's that it shouldn't be consumed unless defense counsel has an opportunity to test it or there's a court order. This case is unique because it was jointly.
you need to speak up a little?
This case is unique because there was two different ongoing investigations at the same time. There was a state investigation and a federal investigation. And the federal authorities consumed the sample. I have the forensic examiner here from Quantico, Virginia, to put on factual testimony as to why it was consumed. I also have him here to rebut certain aspects of the motion and to show that all the records are available for their expert if they get one to review and see if the testing is correct. And I also would call Detective Burton as regards these investigations and how they ran parallel, but information was shared. And then I would call Special Agent Johnson tomorrow if necessary. But the Commonwealth believes that the controlling case on this is Tighe versus Commonwealth 600 Southwest 3rd 140. And it's our contention that before this can be excluded under due process grounds, that they have to show that the officers acted in bad faith in destroying the evidence in this case. Teague sets out a three-pronged test, and the bad faith has to be shown before you even get to the other two prongs. And that specifically deals with this statute, this consumption statute. So, and I have a copy of the case.
I read it.
Okay. So.
Well, you get counsel, do you agree that we get down to a situation of bad faith as a component of this? I mean, you can show certain things, I would assume, are so blatantly done that they would constitute bad faith. Is that what you're saying?
No, that's not the entire
Well,
argument.
let me let you say what you're saying.
Judge, I think the controlling cases come from Basham versus Commonwealth and Elkins versus United States, which are cited in my motion. So the issue is, was there a joint investigation between state and federal officers? If there was there collusion to avoid requirements of either state or federal law? And then can that be admitted in the court where they violated the law or the procedure of that court? That's the first question. If the court finds that there was not collusion and that they did not purposefully avoid Kentucky law, then the issue of bad faith under Youngblood comes to light. And I do think there was bad faith.
Yeah.
So I would like to question the couple's witnesses today. But the issue raised in my motion is the action of the law enforcement
Yeah,
officers.
I read your motion, and I do think that the aspect of being a joint investigation, you said there were two separate investigations. But in the documents that I've seen, it appears to me that there was a joint investigation because they did go and interview the witness together. They did, although there was a search warrant issued by this court on one aspect, there was the bodily search warrant was issued by the federal magistrate. She issued that. I
Well,
believe.
let me clarify. There was sharing of information, there was joint work on the case, but there was an open investigation opened by the U.S. Attorney's Office or by the FBI. They got authority to open an investigation. Likewise, the KSP opened an investigation in case the federal authorities couldn't pursue their case.
Well, I don't think the fact that both of them had an investigation going on excludes us from talking about this as a joint investigation. There's nothing pejorative or negative about having a joint investigation. I think it's probably done all the time. If they decide to prosecute at the U.S. Attorney or at your office, they would be predicated on the laws that would be in place in the Commonwealth of Kentucky or the federal laws. So those are two different prosecutorial decisions.
The other thing, if I may, Your Honor, if I may
Sure.
mention, she used the word collusion. The cases she cites are about 40 years old. There's a progeny of cases after that. One of those cases deals with the word collusion, and it basically says that the officers colluded in order to exclude certain evidence that they acted in bad faith. And then later on, 13 years after Green, the case they cite, Kentucky Supreme Court in Collins versus Commonwealth adopts Arizona versus Youngblood, the bad faith standard. And then the Teague case sets it out in detail.
Well, let's cut to the chase on this one. It appears to me that certain evidence was gathered by the Kentucky State Police and then turned over to the FBI to be tested.
That it was turned over to the FBI, yes, to be tested. And then later the FBI gets a search warrant to get Mr. O'Donnell's buccal standards to
Which
complete
was
the test.
That's correct.
Yes,
But I mean, that's just a factual situation.
That's correct.
We would probably stipulate to that is that there was certain swabs and other investigatory activities done with forensic evidence gathered by the Kentucky State Police and then turned over to the FBI. And the FBI went out and met with the defendant and took a swab. But the Kentucky State Police officer was with him when that happened also, I believe.
may have been. Inspector Burton clarify that. I'm not aware.
That's what it's attached to the.
Yeah.
To the information. So I'll let you, I'm particularly interested on this an explanation of the gathering of the forensic evidence and what was predicated the decision to have it processed by the FBI laboratory
Okay.
rather than Kentucky State Police.
Well, I'd need to put Detective Burton on for that and Special Agent Johnson, who will
We
be
can put
here
him on tomorrow.
in the morning. Yes.
That'll be fine.
And I would like to, just to preserve the record, I would like to put the lab examiner on first to show the process, what he went through. And I think one of the key elements of this, whether you rule on it or it goes on appeal, is whether or not there's adequate information for them to hire an expert and whether or not they were prejudiced by not being allowed to test this. And I think I would need to put the lab examiner on for that. Because they've alleged in their motion that there's cross-contamination possible that would have prejudiced the defendant at O'Donnell. But according to the lab examiner, that is impossible in this case because they didn't even have the buccal standard yet.
You know, the bothersome thing is there's a specific statute here that requires action to be taken when when there are, and I deal with them not real frequently, but several times a year about consuming and they want to have somebody present. I don't believe they have a statutory right to have separate tests done, but they do have a statutory right to have somebody present. And I'd like to know whether the exam was filmed or that, just a lot of
Trying to
things
put
like
the
that.
lab examiner on for that.
Okay.
Yeah.
Okay, well, for the sake of his travel expediency and that sort of thing, we do want to call the FBI lab.
First, if I may.
It's kind of out of order. Yeah, I want to object to that, will you?
That's fine, but we would invoke the rule, Judge.
Of course. If you invoke the rule about the
Yeah.
test, anybody that's involved in the test, they just got one prosecuting officer with them, I see. here.
Yeah,
They
and
can
Detective
designate
Burton
him.
will be our representative.
They can designate him to sit at the table and anyone else will be excluded. You want to call your first witness?
Yes, Jeremy Fletcher.
You want to take the stand over here, please? When you raise your right hand, you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Please have a seat there, and you'll need to lean forward toward the red microphone and speak distinctly. State your name and with whom you're employed.
Your Honor, there's one other housekeeping matter we need to take up first. In order for Mr. Fletcher to testify and Special Agent Johnson, I need to file with the court what's called a coup, which limits the scope of their testimony to what's outlined, what we've discussed in this way. What we've discussed. Under the supremacy clause, they say we can't ask anything else other than what he's been authorized to test to.
I'm all about the supremacy clause.
Okay.
If you want an opportunity to review that,
I'm reading it, Judge.
we'll hold off a second.
That's fine.
That's fine, Judge.
Okay, that'll be fine. Without objection, this will be marked and placed as an exhibit to Mr. Fletcher's testimony. Mr. Fletcher, you want to identify yourself and with whom you're employed, in what capacity?
Sure. My name is Jeremy Fletcher. I am a supervisory forensic examiner in the DNA casework unit at the FBI laboratory in Quantico, Virginia.
Okay, you may proceed, Mr. Stockton, with your inquiry.
Mr. Fletcher,
And Counselor, you can go back to your table if you're more comfortable there. You can remain there either one. Okay.
Thank you,
Go
Judge.
ahead, Mr. Stockton.
did you furnish my office a copy of your CV in order that describes your qualifications and education?
I did.
And I'm gonna show you what's been marked as Commonwealth's Exhibit 1. Is that a copy of your curriculum this high school?
Yes, sir.
Since this is not a jury trial, Your Honor, I'm just gonna ask this to be marked. You
I'm
know,
gonna mark it as two, as one was the letter of limitation of the question. If you give us a copy of it though.
oh, well, let me just mark it with one, put a 2 on there.
Clerk, thank you.
Now, Mr. Fletcher, I want to,
Do you have any objections to Mr. Fletcher being received as an expert witness?
No, Judge.
Okay, you may proceed.
Mr. Fletcher, I want to ask you in this case, what type of DNA testing was pursued?
So in this case, we did DNA testing. There's multiple forms of DNA testing. In this case, we did autosomal DNA testing, which is testing the DNA that's inherited both half from your mother and half from your father.
Okay, and is that a process that you go through, is that a 5-step process?
Yes, the DNA process has 5 steps: collection, extraction, quantitation, amplification, and electrophoresis.
I have the bailiff close those curtains over there. We're not getting a real clear picture of him. The blinds, that's fading. And the other set of blinds there, please. That's much better. Thank you.
Okay, could you briefly describe those 5 steps of the process used?
Sure. Those 5 steps are the same steps we use in any DNA testing in any case. So the first is collection. That is a process by which we collect the DNA for testing. It can be done in a variety of ways. If you have a bodily fluid, such as a blood stain or a semen stain, it could be cutting the blood stain off of the shirt and using that cutting as a sample. We can also collect samples from handler or touch DNA. So that's when someone may have come in contact with an item, and we're looking to try to recover the skin cells that are left behind through handling that item. That collection is done by swabbing the item. So a swab is like a sterile Q-tip. You add water to that and rub it over the surface of the item to collect any skin cells that may be present.
And that's the type of collection that was done in this case. Is that correct?
Yes, and that collection can be done by different individuals. It can be done by individuals in the field, such as the law enforcement officers or laboratory technicians in the field, or it can be done in the laboratory. You can send the item itself into the laboratory, and we could do the collection in the laboratory. Once the samples are collected, so the cells are collected, then they go through an extraction process. Extraction is a process by which we add a series of chemicals, use a specialized instrument to remove everything but the DNA. So all that's left is the DNA. After that's done, the third step is quantitation. This is where we determine how much DNA did we actually recover, because we need a certain amount of DNA to optimize the DNA testing.
And go ahead. How much DNA would you need to optimize it when you're doing handler DNA?
Through any DNA processing, we are looking for 1 nanogram of DNA. That's a millionth of a gram. It represents about 175 cells or so. Once we know how much DNA we have, like I said, we want to target 1 nanogram of DNA. We do amplification. And amplification is a process by which we add a series of chemicals, use a specialized instrument that makes millions and millions of copies of the DNA parts that we're interested in forensically. Once we make those copies, then we do the last step, which is separation. This is where we add that amplified or copied DNA to an instrument, and it separates the DNA into its individual components so that I can look at as a forensic examiner and do my comparisons to include or exclude individuals.
Okay. Now, in this case, just so I'm skipping ahead just a little bit, but just so the court can follow, you generated a report after the testing was complete, didn't you?
Yes, once those 5 processes are done for all of the evidence samples submitted, so the samples collected in the field, the samples sent to the laboratory, as well as reference samples collected directly from individuals, then I would compare those DNA profiles and offer my report to what those conclusions were. Were there inclusions or exclusions? And anytime there's an inclusion, I have to generate a statistic that provides weight to that inclusion.
Now, did you generate a report in this case?
I did.
On your approach, Your Honor, did you identify that document?
Yes, this is a copy of the report I issued in this case.
Your Honor, that's almost next exhibit.
Number 3, without objection.
Now, I want to ask you, in general, were the swabs that was collected by the Kentucky State Police, were they consumed in testing?
Yes, they were.
And why were they?
So the swabs were submitted as touch or handler DNA. So that means it was believed that someone may have come in contact with an item, and a swab was used to collect those skin cells. Because we have no reference to how much DNA was present on the item, and therefore how much DNA would have been transferred to the cells, in order to maximize the chance of getting a full, complete, usable DNA, we try to consume that evidence. When you have touch or handler DNA, we don't know how much DNA is on those swabs. When you have a blood stain, we can look at the blood and base it based on how deep is the red blood color, how big is the stain. So we can estimate how much DNA we recover based on the size of cutting we take. But when these are swabs of substances that may have been touched, there's no known or estimatable amount of how much DNA would have been recovered and transferred onto those swabs. So to maximize the chance of getting as much DNA as possible, we try to consume the swabs when possible.
Now, I want to go in specifically on each item. I want to specifically ask you the items where it was determined that Thomas O'Donnell, the defendant, was a contributor on these items. And the first one I want to ask you about is item 3. You have in your notes in front of you.
I If I had my report in my notes, I could answer any question you have, but I might know some of them.
Well, my question, you might want to, could he retrieve those, Your Honor, before we go any farther? Can you retrieve your notes before you go? any
Yes, I
farther?
can.
And the first item I want to inquire about is item 3. And how many swabs were consumed in the testing process?
So item 3, which was submitted to us as 7 swabs from the inside driver door hold area of the Dodge Ram. So there were 7 swabs submitted from that collection area, and we consumed all 7 of those swabs.
After the consumption of the swabs, how much DNA was
Your
extracted?
Honor, I'm gonna object. This is beyond the scope of my motion. My motion deals with the police officer's conduct in permitting the consumption prior to this analysis. So whether or not the labs took
You
the
wanna come up
appropriate.
where I can hear you, or?
Judge, this is going beyond the scope of my motion. I'm not challenging the lab's procedure or the amount of DNA collected. The issue is the officer's actions in permitting the consumption of the DNA when they submitted this to the lab. So I think going into this as
Well,
far
what he's
as,
doing now is explaining why they consumed it all.
well, he's
And,
already,
well, and, or you can go ahead and anticipate what I might be about to say if you want to. We'll get
Sorry,
through this a
Judge, go
lot
ahead.
quicker if you'll let me finish.
Yeah.
The situation here is he's telling you why he consumed it all. And what you're saying is you don't care whether he consumed it all or not. He did so without notice to you. Is that correct?
the issue is that they consumed it without a court order, and he's testified that they consumed all of the samples that are in question.
Well, without a court order, without a court order, he consumed it all, and that's your problem. You know, you're not questioning whether they wrongfully consumed it all, correct?
Exactly,
But
yes.
all this goes to whether all these officers and law enforcement, they're trying to impute bad faith to everybody. And I think this goes to whether anybody acted in bad faith in this case.
Well, I don't know whether they're saying anybody acted in bad faith or not. I read they might bring that up later, but I guess you're talking about collusion.
Yes.
Yeah, is what you're talking about. And that gets to a bad faith question of whether collusion was so obvious that they should have known better. But for the sake of preservation of the record, I'm going to let him testify about what they did. And then later on, you can bring up why the FBI had it and why the state police lab didn't have it. that
We're
sort of
going to
thing.
begin that today after Mr.
Okay,
Fletcher.
well, those
testifies.
things will be informative, but I understand your objection. And I will allow him to testify beyond the scope of your particular motion for the purpose of protecting the record, okay?
And Judge, if the court's ruling is at all based on this, that's beyond the scope of motion, we would want to put our expert on. So that's why I'm objecting to this, because our expert has a different opinion about the consumption of the DNA. I did not bring her to this hearing because that's not the issue before the court today. So I just, as long as I'm not waiving that issue, Judge,
You
and I
won't
can
waive
bring
it, I'll
that.
let you.
Well, and I think that's kind of, you know, I don't want to be litigating motion after motion after motion to get a trial date. If this was an issue and they believed it was an issue, they should have had their expert here instead of filing another motion. I don't want to run this gentleman back and forth from Quantico, Virginia 5 times.
Well.
And I don't even know if
he won't
the
be-
US
he
government
won't
would
be
allow
run- He won't be running back. He's gonna take he's gonna take the testimony and we'll let him observe as an expert witness. I think he has the right to observe testimony of an expert witness that's countering his situation. And we'll make sure he can observe it by Zoom necessary, so we won't have to run back and forth.
Okay.
But I would remind the prosecution that the prosecutorial decision was made to make this a death penalty case. And
It's been withdrawn at this point,
but I understand,
but it may be refiled.
it's always a possibility, you know?
Yeah.
So let's just all just take our time and measure once before we cut. And I'm gonna let all this testimony in, and then if you believe that after you hear it, if I tell you that that's gonna influence, his testimony is gonna influence me, I will give you an opportunity to present your witness and not necessarily have to bring your witness, but by Zoom.
Thank you,
Okay.
Judge.
You may proceed.
Okay. Now, Mr. Fletcher, if I can remember where we were, on item 3, I believe. I think my last question was how much DNA was extracted after all those swabs were consumed?
So we consumed all 7 of the swabs that were submitted from that area, and that resulted in our ability to amplify 0.35 nanograms of DNA. So 35% of what we target or try to attempt to use in our processing. That was all that was recoverable.
And when was that item? What date?
So the swabs from the inside driver's door handle, item 3 from the FBI. That was done in our second round of testing. So we
Let me
initially,
ask you a question. Did you consume enough to make any judgment on what?
we did, we recovered 35% of what we target, but it did give us some information, not a full complete profile, but enough that we can make a determination about inclusion or exclusion.
Go ahead.
Now, as a result of, even though you only recovered a third of what your target was, you were able to make a judgment as to whether or not Mr. O'Donnell was a contributor. Is that correct?
That is correct.
Okay.
Wait, whether he was a contributor or whether he was included or excluded, which one?
Well, my question was a contributor because if you look at the results, he was a potential contributor to that item.
Well, that's a potential contributor.
Wait, I'm sorry. He was a contributor. I'm sorry. I'll take the word potential out.
So inclusion or potential contributor, we kind of use those synonymous. So when I do the comparison, I say whether someone is excluded or included when I do my comparison. Then I do my statistic, and the statistic says what is the weight of him being a possible contributor to the DNA that was recovered. So they can almost be thought of as
And I
synonymous.
agree, what was that?
I'm sorry, the weight. So for item 3, the swabs from the inside driver's door handle, I interpret as being male DNA and originating from 3 individuals, one of whom was Mr. Harding. When comparing Mr. O'Donnell, it was determined that the DNA results from those swabs are 1.6 quintillion times more likely if Harding and O'Donnell and another unknown person were contributors than if Harding and 2 unknown unrelated people are contributors. And this provides very strong support for inclusion of Mr. O'Donnell to this DNA mixture. And quintillion would be a 1-6 followed by 17 zeros.
And my question, I don't know if it was ever answered or not, when was ultimately all swabs consumed? Do you have what date that was?
So the swabs were consumed in our 3rd round of testing. So we actually did 3 rounds of DNA testing in this case. A first round of evidence was submitted. We did some testing. A second round of evidence was submitted. We did some additional testing. And then through communications with Special Agent Johnson, we discussed going back and testing a 3rd round. So some of the stuff that was submitted originally went back and retested. That was not tested the first time, I'm sorry. So this was done in that 3rd round. So it was tested in the 3rd set of DNA testing that was done. And those processes started on March 1st and ultimately ended on March 15th, that round of DNA testing.
That would have been 2023 or?
Yes, 2023.
Okay. Now I want to go to the next item, which would be item 10. And was, based on your testing, was Mr. O'Donnell a contributor to that mixture?
Ask him to tell me what item 10
Okay,
was.
what was item 10, Mr. Fulcher?
So item 10 in my report ultimately is a combination of variety of swabs from the steering wheel. So there were 12 total swabs from the steering wheel that were submitted. They were entered into evidence in the FBI laboratory as items 10 and 11. But because they were all from the steering wheel, we combined them during our analysis to try to maximize the amount of DNA that we could use and test for those steering wheels. So that was the testing of item 10.
Okay. And how much DNA was extracted from those swabs?
So for item 10, once we consumed all 12 of the swabs, we ended up being able to test 0.55 nanograms of DNA. So just a little over half of what we target for our attempt to use when doing our DNA.
Okay. And what was the results of the test as far as Mr. O'Donnell being a contributor?
So for those swabs from the steering wheel, it was interpreted as being male DNA and from three individuals. Again, one of whom was Mr. Harding, because it was his vehicle. I would expect his DNA to be present. The DNA results from those swabs from the steering wheel are 6,200 times more likely if Harding, O'Donnell, and an unknown unrelated person, because there were three people in this mixture, are contributors than if Harding and two unknown unrelated people are contributors. This provided moderate support for inclusion of Mr. O'Donnell to this DNA mixture.
And when were those swabs consumed and tested?
So those swabs were done in the first round of DNA testing that we did. And the collection that started on November 14th of 2022. And the DNA testing ultimately completed on November 22nd of 2022.
And the last item I want to ask you about is item 18. Could you identify that item, please?
Item 18 was two swabs that were submitted from the key lockbox in this case.
Okay. And what was the results of the test on that?
So we consumed both of those swabs and recovered about 0.26 nanograms of DNA. So about 26% of what we would normally target. When we did that DNA testing, it was determined that a mixture of male and female DNA was recovered from these items, and it was interpreted as originating from three individuals. When comparing Mr. O'Donnell to this DNA mixture, the DNA results from these swabs are 6.1 million times more likely if Mr. O'Donnell and two unknown unrelated people are contributors than if three unknown unrelated people are contributors. And this provides very strong support for inclusion of Mr. O'Donnell to this DNA mixture.
Okay. And when were those two swabs consumed and tested?
These swabs were done in parallel with those swabs from the steering wheel. So in the first round of testing, so it'd be during the same time period, November 14th through November 22nd, those swabs were processed.
Okay.
Now,
Now,
who was the agent that you were dealing with?
Special Agent Wayne Johnson was the,
I'm not as familiar with your protocols, but it's been my experience in the state crime lab. A number of items will be submitted, and then there's communication and direction as to which items that the investigating officer wants tested, or if there are other items, there's a decision by the lab that's made, which ones will be put together. Who makes the decision here?
so in this case and in most cases, the agents submit the evidence to us. I, as the forensic examiner, I do an evaluation of the case and an evaluation of the evidence that was submitted. And I determine which items are the most likely to provide usable and probative results to the agents. I will then test those items of evidence, and then I will communicate the results back to the contributor, so the Special Agent Johnson. In that case, usually we'll have a communication to determine if there were items I excluded not to test, if those need to be tested. So in this case, that's why there was that third round of testing, because through that communication, we tested more.
now I want to go to a little different topic before we go on to the lab procedures. In the defendant's motion, they alleged that they needed an expert present at the testing to observe the test or do their own testings to eliminate the possibility of cross-contamination. Could you explain to me in the court what cross-contamination is?
So cross-contamination is the process which by DNA from one sample can be transferred inadvertently to another sample. So it can be done in a number of ways. It can be done at the field during collection, or it can be done in the laboratory when it's processed. We do everything we can at the laboratory to prevent that through our standard operating procedures. So the first thing we do is during that DNA collection process, we only process one item at a time. So the way we do our processing would be we clean our work surface, lay out butcher paper, and then start on one item. So for example, item 3, the swabs from the driver's door hold area. Those would have been taken out, and we would cut those swab tips and put them into individually barcoded tubes. Those would all get closed up, put to the side, and then we clean the surface. So we remove the butcher paper, clean our tools and surfaces, put out new butcher paper, and move on to the next item of evidence. For example, the swabs from the steering wheel, do the same thing. We would cut those samples, add those samples to barcoded tubes, and then repeat that process for each additional sample, never having more than one item out at any one time. Once we do that, now all of the collected samples have now been put into these barcoded tubes that we can track using our laboratory information system. At that point, we only have those samples open one at a time whenever we're doing human manipulation. So during the extraction process, we have to add chemicals. You only ever open one sample at a time, add the chemicals, then close that and put it to the side. Open the next tube, add chemicals, close it up, put it to the side. The only time that those samples would be open at the same time would be when we're using an automated process. So we have validated a number of instrumentations that use robots to transfer liquid from one sample to another or from one sample to another plate. At that case, it'd be the only time when more than one sample is open at a time. So you would open all the samples, place them onto a robotic process, and the robot would do the processing of those samples. The robot's been validated and shown that it greatly reduces the chance of contamination by doing the same steps over and over and over by a robotic process. And it was validated and tested by taking samples with high amounts of DNA and samples with low amounts of DNA and put those next to each other to see, does DNA transfer from the high amounts to the low amounts? And we did that validation to show that that didn't occur, that doesn't occur. We also, during our steps, we have what are known as controls. So we have samples that are negative controls. These are samples that have no DNA in them. We add all the same chemicals, we do all the same processes to show that we are not adding anything to the process. We're not contaminating the DNA. We're not having our steps in a process by which DNA is flowing about and flying around and available for cross-contamination. And in this case, none of our negative controls, none of our process showed any sort of contamination or any indication that something went awry in these instances.
Now, in order for cross-contamination to occur that would be to the detriment of the defendant, Mr. O'Donnell, some of his DNA would have to be added extra. Am I saying that correctly? In order for him to get a worse result on the lab report?
So in order for us to contaminate Mr. O'Donnell's DNA with the swabs from the steering wheel or the swabs from the key box or the swabs from the inside of the truck, we would have had to in some way introduce Mr. O'Donnell's DNA to those samples. And in this case, Mr. O'Donnell's DNA was actually processed at completely different times than all those samples were processed. We talked about the times in the processing. So the swabs from the key box and the swabs from the steering wheel were processed through the laboratory in November. That was our first round of testing. The swabs from Mr. O'Donnell were processed in the second round. So we received those into our unit in February of 2023, and the processing of Mr. O'Donnell samples occurred in February. All of those results were done at different times, so different spaces. Then the third round of testing, the swabs from the inside of the car, were conducted in March. So in order for us at the laboratory to have inadvertently contaminated whether the swabs from the key box, the swabs from the steering wheel, the swabs from the inside of the car with Mr. O'Donnell's DNA, the first thing that would have had to occur, which they would have had been processed at the same time in a manner that allowed for contamination. Not only do we not process things in a manner to allow contamination, but they were processed at completely separate times. So at no time did anyone handle any of these items at the same time. The only time they were actually even in the custody of someone at the same time was when they were returned to the field office at the end of our testing.
Now, the court asked earlier, this testing process, is any of that videoed or you keep notes? How's it memorialized and recorded?
So none of it is videoed. The way we do it is by recording everything we do contemporaneously in our laboratory information system. So the person who does the collection, the sample by which they cut the cotton off the swab tips, they do all of that and track all of that into our LIMS system. So they will go into the system, they will take custody of the evidence, they will then document everything that they did. So they documented What was the description of the packaging before they opened it?
Kind of like electronic lab notes.
It's exactly what it is, Your Honor. Then they would describe what they did, that they cut the entire swab tip off, that they put it into the barcoded tube with the barcode of XYZ, whatever that was. All of that stuff is tracked. Then the person who does the extraction, they open barcode tube XYZ and added chemicals with lots 1, 2, and 3 to that. All of that is tracked and maintained in our laboratory information system. And that's what's used to document what we do, when we do it, and who did it.
Now, I'm just about finished, Your Honor. When you furnished discovery in this case, I had you to look over these 4 folders. Could you identify, this has all been furnished in discovery, this is the lab notes and things, but I didn't make you a copy, you can see why. Could you tell the court what is included in those 4 files?
So previously to testifying here, I reviewed, this contains a copy of my curriculum vitae, a copy of our laboratory notes. So that information that we recorded, it's about 560 pages of that information, as well as copies of our standard operating procedures. So those are the protocols and the directions that we follow to do all of the steps I talked about. The collection, the extraction, the quantitation, all of those steps have the procedures documented and laid forth and that we follow on a daily basis.
Your Honor, for the purpose of this hearing, I'd like this to be the next number of exhibit, it's Commonwealth's cumulative.
I believe it's number 4.
I don't think I have anything else for the witness.
I don't want to step on your cross-examination, but I have a question or two I'd like to ask since I'm the fact finder here, and then you can come up and do that. As I was preparing today, I noticed that these laboratory examination requests were here. And I would assume that they're generated, they have a federal form on there when it was revised, that sort of thing. But on there, they have examination requests. And one of the examination requests, it says if DNA requested, select an option. And one of the option is permission is granted to consume item stains during DNA testing process. It was highlighted, I believe, Counselor, in your motion. So is the decision made by the officer that submits the items for examination, or is it by the examiner? If this officer who did submit it for examination says permission is not given to consume it all, how would you have proceeded then?
So it's kind of a joint collaboration. So they provide the permission to consume, and then we determine at the laboratory whether we need to consume it. So in this case, if it were a blood stain, so there were some suspected blood stains from a vehicle submitted. If we had determined that there was a blood stain on one of these swabs, we would have determined about how much of that swab do we need to collect in order to get a reasonable amount of DNA or the target amount of DNA. If that had occurred, that would have been my decision, how much of the swab to cut. So they gave us permission to consume the swabs, and then I, as the forensic examiner, said I wanted to consume all of the touch or handler DNA swabs to maximize our chance of getting enough DNA for information so that we can possibly include or exclude someone. If the agent had selected the box and said permission was not granted.
Or to contact the author to discuss permission, that was the other option.
Those are the other options. Then what I would have done was contacted them, and I would have laid out what samples I would want to consume and why I would have wanted to consume them. It would be then, I would wait for him to come back with a response that either my reasoning is sound and the sample should be consumed, or due to jurisdictional requirements or whatever it may be, I'm not permitted to consume them, and then I would have to abide by those. And so I would have taken less than what I would have wanted in order to do the DNA testing. So it's a collaboration between us and the contributors.
Okay, I'll have a final question. I'll turn him over to you. I hope I'm not messing up your cross-examination anyway. Are you familiar with other jurisdictions that have limitations on consumption without court order of testing? You come across that and, you know, you deal with all 50 states and probably some territories.
Yes, we do, which is why we have that checkbox in the information. We cannot keep track of every judicial area, of every proceedings and what needs to be done. So we leave that to the onus of the contributors who are submitting it to us to understand their local laws and regulations. So if we were provided information that we could not consume the evidence, then we wouldn't have. I would have just taken less DNA than optimal, or what I would have thought was optimal to do the testing, and I would have proceeded with that. But we rely on the agents in the field or the contributors in the field to understand what we are allowed or not allowed to do, and we work with that.
On the day that you did these tests, were you aware of Kentucky's statutes involving that at all? Did you have any personal knowledge of that on this day?
I have no personal knowledge, no, Your Honor. I saw the checkbox that said permission was granted, and so I did what I thought was best for the evidence in this case to get as much information as possible so that I could include or exclude as many individuals as I could.
Counselor, thank you for the courtesy presentation. You may proceed.
Good afternoon, Mr. Fletcher.
Good afternoon.
Sarah Zercher representing Mr. O'Donnell. So I'm going to pick up where the judge left off regarding the laboratory examination request submitted. Judge, may I approach the witness?
Sure.
Is this the laboratory examination
Yeah, I'd
request?
like to use the Elmo to get this on the record. While you have it, okay, would you go over, let's document?
Sure.
Yep. Clerk will come over and place it for you, make sure it comes up right. Okay. We'll turn the device on. Okay. we'll flip the Elmo off now since we have context to what you're talking about.
It does not appear as if there's any expedited results requested.
And on page 4, again, the same question about if DNA is requested, please select an option. Can you tell the court which option Agent Johnson selected?
He again selected, permission is granted to consume items, stains during the DNA testing process.
And when you say consume, what do you mean by that?
So consume for an item could be completely using the item for DNA processing. So in this case, they were swabs. So what we did was we took the swab and cut all of the cotton tip off the top of it. Consume could also be if there's a potential blood stain on a shirt, taking the entire blood stain off of that. So consumption just means using all of the DNA that was on the item of evidence to try to get a DNA profile.
So when an item is consumed, the raw material no longer exists after that.
Depending on the nature of the item. So these were swabbings of steering wheels or cars or lock boxes. The items themselves still exist. So you could always go back and re-swab them if needed, but it is assumed that the original swabbing or the first swabbing would remove the majority or the most of the DNA.
And so those original swabs cease to exist when they're consumed during testing.
That is correct.
Okay. And I think you mentioned earlier that the lab technicians can't tell how much DNA is on a swab until the extraction process is already completed.
That is correct.
Okay. And I know you were discussing some of the lab's policies about cross-contamination. I'd like to draw your attention to the lab's manual regarding analysis, interpretation, and reporting of STR data.
Thank you.
Okay, and if I can draw your attention to page 38 of that manual. In section 7B, there's language about attempting to preserve DNA material. Could you read that paragraph, please?
Sure. This is our STR interpretation manual, which is titled BIOS 570 version 00. And under section 5.6.10.6, evidence, I'm sorry, I back up. Under section 7, limitations. Number B reads, all reasonable attempts are made by the DNA personnel to preserve material, i.e. evidence material and or isolated DNA for potential future DNA. However, it is sometimes necessary to consume a sample, e.g. a small blood stain, in its entirety, i.e. no original material or isolated DNA would remain, to ensure that the best attempt possible is made to obtain DNA results for comparison purposes. Should the total consumption of a sample be anticipated by an examiner, or should the performance of any additional examinations result in the total consumption of a sample, an examiner should ensure that the contributing agency or other reasonable office, e.g. Office of the United States Attorney, is contacted concerning this necessity. Based on this discussion, a mutually acceptable strategy should be developed concerning the future testing of a sample. For TDAC cases, samples will be consumed at the discretion of the SBAU, which is initial for the Scientific Behavioral Analysis Unit.
And can you tell the court what a TDAC case is?
A TDAC case is a Technical Explosive Device Analytical Center. So these are cases that are submitted generally of IEDs or explosive materials for analysis.
And that was not this case.
That is not this case.
Thank you. And Judge, I believe that manual has already been admitted through the case file. So it was in your case file?
This would have been one of our standard operating procedures and provided, yes.
Thank you. Your Honor, may I approach the witness? I'm now handing you the quality assurance manual. Do you recognize that?
I do.
Okay, and I would direct your attention to page 22 of that manual. We're in section 7.6, letter D. And can you verify, or I guess just read that paragraph for the court, please?
Sure. Again, this is the DNA Quality Assurance Manual or QA manual, and this is labeled Bio 101 version 0. We are in section 7.6, examination of evidence, and this is item D. DNA personnel should use the amount of evidence considered necessary to provide DNA typing results. It is noted that while every attempt is made not to consume the entirety of a particular item of evidence, to allow for possible re-examination of that evidence at a later date by another laboratory, the primary goal is to use the amount of evidence necessary to provide DNA typing results. When sample consumption is necessary, a concerted effort to obtain authorization from the prosecutor or contributor to consume evidentiary material will be made prior to the initiation of DNA examinations, i.e. extraction, on the affected items. A record of these communications will be retained within the case records. And then there are subsections.
Thank you. And Judge, this has already been admitted as part of Mr. Fletcher's case file. So everyone in your lab is bound by these procedures, is that correct?
Well, those procedures are actually just for the DNA case working unit. So everyone in my DNA case working unit is bound by those
Okay,
procedures.
so everyone who would have worked on this case in the DNA part.
Yes,
Okay. And so that indicates that not only are you required to make the concerted effort to get authorization before consuming a sample, but also to keep a record of any communication where you got that, where you had that conversation. Is that right?
that is correct.
Okay. And I think you testified earlier that if Agent Johnson would have marked either of the other two options, you would not have consumed the samples without reaching out and consulting with him first, correct?
That is correct. By him checking that permission is granted box, that checks the box for me that permission is granted and I have reached out to the contributor to get permission. If he had not checked that box, then me and him would have had a dialogue about the best way to proceed on the evidence.
Okay, so when they check the box granting that permission, you're saying that that is all the permission you need to go ahead and consume the evidence if you decide that that's necessary?
Yes, if in my determination, I think it is the best for the analysis of the evidence of items, then I will consume the evidence if he has given me permission prior by checking that box.
Okay, and when the lab performs consumptive DNA testing, is it common for experts from defendants or defense counsel to observe that testing?
I'm not aware that we have ever had anyone come to the laboratory for observation. Due to the sensitive nature of the evidence that is at the laboratory, we usually provide other alternatives such as not consuming the evidence.
Okay, and I want to move on to the specific items that we're talking about today. So we're focusing on items.
I asked a question. It appears that these rigs that you operate on, or these procedures you operate on, anticipate that you'll have a submitter and then maybe at a later date, you'll have a prosecutor involved.
Mhm.
But sequentially, most frequently, you don't have a prosecutor involved when they initially submitted. Is that what you're saying?
So I rely on the agent for those kind of things, or the investigative authority, or whoever is sending this stuff to me.
That's
It
your
is
contributor.
yes. So the contributor is going to be working, my understanding, I am just a lab rat. My understanding is in the field that he or she will be contributing with all of the appropriate authorities
Yeah.
to make sure that we have the proper authorization.
Thank you.
Okay, and going specifically to the items in this case, I think you testified earlier that 10 consisted of 6 swabs from the steering wheel of the victim's truck. Is that correct?
Yes, item 10 was 6 swabs and item 11 was 6 swabs, and those were ultimately combined.
Okay, right. So those 12 swabs were cut and combined prior to extraction. Is that correct?
They were combined either prior to extraction or immediately after extraction to maximize the DNA.
And every single one of those swabs was consumed?
Yes,
Because you testified earlier that when it's touch DNA, you try to consume all the swabs so that you can get the biggest sample you can.
yes, because we don't know how much DNA is on those swabs, we attempt to consume them to maximize the ability to get as much usable DNA as we can.
Okay, and item 18 you testified was 2 swabs, and that's from the key box on the front door of the home. Is that correct?
It was from a key box. I don't know exactly where located, but it was 2 swabs from that key box.
And you testified that those extractions and that testing occurred in November, from November 14th, 22 to November 22nd, 22.
Yes, that was when the analytical processes, the collection, extraction, quantitation, amplification, and separation all occurred.
Okay, and during the extraction step, so we're on step 2 of 5, correct? At that point, all of the swabs have reagents added to them in the tubes, is that right?
That is correct.
And so once the reagent has been added, the raw swab does not exist in its original form. Is that fair to say?
Correct. Once we add the chemicals to them, then now the DNA, the purpose of that is to remove the DNA from the cotton and to get it into solution and ultimately break it down so that only the DNA is left. So those cotton swabs are basically no longer needed, and we ultimately throw the cut swabs away as part of that extraction.
Let me ask, is the residue still in existence?
So the only thing that is in existence,
Extract. The extract on existence.
it is, but we did use a majority of the extracted DNA to get the results that we used. So in this instance, we ended up with 15 microliters. That's a measure of volume. We used 13 of that. So there's only 2 microliters left in that extracted sample that would be available for anything else. Because there was not enough DNA to reach our target, we used the maximum amount that we possibly could, and that was using all 13 microliters.
And one person doesn't do every step of the analysis, right?
No, they do not. In order to maximize efficiency and to make sure people are as proficient as possible, our technicians are qualified in certain steps. So the collection would have been done by one individual, the extraction could be done by another individual, quantitation, so forth. So up to 5 different individuals could handle this through those 5 different processes.
Okay, and in this case, once samples 10 and 11 were combined, they were put in tubes by Curtis Galt. Is that correct?
Curtis did the collection. So he's the one who cut all of the swab tips off and put them into the barcoded tubes. So he did the collection.
And then the extraction was started by Candy Alvarado on November 17th.
That is correct.
And then they were combined and concentrated, and that was by Lily Wong on November 21st.
Yes, that is the first step in our quantitation process. In order to try to get as much DNA in as small amount as we can to maximize the recovery, Lily concentrated all those samples down, yes.
And then they were amplified by another person, Jessica Lamb.
Jessica McClam, yes.
Okay. And once the DNA samples have been amplified, can that extract be preserved and be tested by another lab if it's not all used?
It would be possible. The problem is that amplified DNA, it ultimately breaks down and isn't needed or isn't used anymore. So that could be used by another laboratory, but we do not maintain that. We ultimately discard that after a certain amount of time.
Would it be more common for it to be saved after the quantitation step?
So the extracted DNA, so the tube that ultimately had the chemicals that had the DNA, that is retained, and that is what gets sent back and is preserved. The amplified DNA, which we call a secondary product, that ultimately gets discarded Because once you run it through the capillary electrophoresis or that instrument, you basically gotten all the information you can out of that sample.
And I think you told the judge earlier that you used the majority of the extract. There was not enough left for independent testing.
Yes, there's very limited DNA left in that extract available.
Okay. And then moving on to item 3, that was 7 swabs from the inside driver door handle of the Dodge Ram.
That's correct.
And all 7 swabs were consumed during testing.
They were.
And you said extraction of those didn't start until March 2nd, I believe, March 1st, 2023.
March 1st was when the collection was conducted.
Okay.
So that's when the processing of that started.
And had the lab been notified by that date that Mr. O'Donnell had been arrested and was represented by counsel?
I do not know if that information was provided. I do know his reference sample had been submitted, so I would assume that just my naivety to the process, there would have been something going on there, but I don't know that it was officially said that he was arrested and there was counsel present.
Okay, and then on March 2nd, all 7 of the swabs from item 3 had reagent added to them.
Is there a referral on his samples they took on him? I didn't see that, the referral request.
On Mr. O'Donnell's sample?
Yes.
Yes, Judge, I can give you a copy.
What was the date on that?
It's 12/20/22.
Okay, I see it now. Thank you.
Okay, so on March 2nd of 23, that's when the reagents were added to item 3.
Yes, they were.
Right, and that at that point, the raw swabs ceased to exist.
Correct.
Okay. And I believe you testified earlier that if you'd been notified that for consumptive testing to occur, a court order is required in Kentucky, you would not have consumed the samples without a court order.
She needs to ask, I don't believe he testified, they asked him that straight up question, okay?
If the lab had been notified that a court order was required before you could do consumptive testing in the state of, for cases in the state of Kentucky, would the lab have waited for a court order before consuming the sample?
Well, you know, I will answer the objection to the Commonwealth now. I think that calls for a legal conclusion as to whether or not the FBI lab in Quantico, Virginia is subject to Kentucky revised statute limitations on testing. Is that what you're asking?
No, I'm just asking if they were provided that information, how that would have affected the steps.
Well, you can ask him that, how it would affect it, but not whether he could or could not, okay?
Does that make sense? Do you want me to repeat the question?
No, that makes sense. It's in rare instances, we are informed that a court order is needed before we can consume evidence. And in those instances, we wait for that court order and the court decision to determine what testing we can provide and what can be done.
Okay, and if the lab is notified that a defense expert is permitted or under court order to observe testing, would the lab have accommodated that request?
We would have responded to it in some way. I do not know that we would have accommodated it, but we would have worked with all of the counsels present to make sure there's a resolution before any evidence was consumed.
And you said at no point in time did either Agent Johnson or anyone from the FBI or the Kentucky State Police notify you that charges had been filed in Kentucky State Court?
I'm not aware that that information was provided. The information that was provided to me was from those incoming communications that we have, and I do not believe in there and everywhere it says that that the state had charges going or that the state had that I had to work with the state in any way.
So in addition, outside of the 2 laboratory examination request forms that you've looked at, there was no further communication between you and Agent Johnson about whether to consume those samples?
Not about consumption. I did communicate with Mr. Johnson to provide initial results and to discuss testing going forward. But nowhere in there was discussion made about consumption was no longer allowed or that we had to worry about consumption issues at that point.
And just briefly, the Commonwealth asked about cross-contamination in the lab. And I know you went through the general procedures, but as we listed out, several different people handle each individual sample as it's being tested, right?
That is correct.
And humans can make mistakes.
They can, and that is possible. That's why we have the standard operating procedures and the steps that we have is to try to limit the ability for those mistakes to occur.
And you mentioned that you have a robot that does automated step because that greatly reduces the chance of cross-contamination, right?
Yes, we use robotic and automated processes whenever possible to limit the possibility of human error.
Right, because cross-contamination is an issue with DNA testing, and that's why you try to prevent it, right?
Yes, it's always something that's there. It's always possible. That's why we have certain steps. That's why we use reagent blanks and controls to try to monitor, detect contamination events. We do everything we can to prevent contamination events from occurring.
And samples could be contaminated by anyone's DNA, right? It doesn't have to be Mr. O'Donnell's DNA.
That is correct. That's why we wear personal protective equipment when in the laboratory. We wear masks and gloves. That's to prevent the technicians or the biologists, the people in the room, from putting their own DNA onto the samples. So there's different ways that you can contaminate, and we do everything in our power to try to limit those contamination events.
And it's possible that cross-contamination can occur in the collection of the evidence by the police, isn't it?
Yes, that is possible if there's any time that you could inadvertently add DNA sample from one item to another, that can occur, and that is a contamination event.
And that's not visible to the naked eye when that happens, right?
Well, I didn't hear that question.
That's not visible when there's cross-contamination. If DNA touches the swab, you can't see that happening.
No, so if a contamination event occurred, for instance, in the field, as we were talking about, where, DNA from the inside of a car was transferred to the DNA on the outside of the car, that would not be noticeable. What I would just get is a DNA profile that contained the DNA from both of those locations.
Thank you. No further questions.
Now, can this gentleman be excused?
I have just a couple of questions here.
Oh, I thought you had.
No, I didn't
Go
speak
ahead.
loud enough.
Sure, go ahead.
Just on the issue of cross-contamination, Ms. Zurcher asked you if another individual was a contributor to the DNA. Would that prejudice Mr. O'Donnell's test result if there was other unknown DNA in the sample, or would that decrease the odds that he was involved in that sample?
So generally speaking, the more individuals in a DNA mixture, the harder it is to give positive conclusions about matches. So hypothetically speaking, if we took a single DNA profile and contaminated it with additional DNA, it is going to be harder to include them positively. So what it would ultimately do is likely lower that weight or lower that statistic, because you're providing more opportunities for different DNA's possibilities in there.
So it would lower the chance or lower the quantitation of the probability that it was Mr. O'Donnell's DNA.
Generally just speaking, depending on the type of contamination, adding extra contributors to a DNA profile, in most cases, especially with low level handler DNA, it will lower that statistical weight when someone is included in a mixture, generally speaking.
And also I wanted to ask you, items 10 and 11 that were combined and items 18 were tested before you ever received Mr. O'Donnell's DNA. Is that correct?
Yes, they were.
So it would have been impossible for there to have been Mr. O'Donnell's DNA cross-contaminated at the lab to be in those samples. Is that correct?
It would have been impossible for us at the laboratory to artificially add or mistakenly contaminate the evidence, those evidentiary swabs with Mr. O'Donnell's DNA.
That's all it is.
Doesn't raise anything, Judge.
Maybe he excused?
He may.
Yeah, well, I better, maybe I'll take his oath to reappear if we have, do an appearance.
I'll have to get that cleared through the U.S. Attorney's office.
Well, I'm just gonna see thank you for your cooperation, your attendance here today. You may be excused.
Thank you.
Yeah. And you have a next witness.
I do. I didn't know. Detective Burton's next. Thank you so much. The Detective Burton's the next witness, and he would be testifying not only on this issue, but also we have the suppression motion. He was present, and we'd introduced the interview through him. And I didn't know if the court wanted to take up the plea from Monroe County before we call him, or if you want to
It'd
go.
be good if they're here. We take a
I
recess.
know Barron County Detention Center's on the line, Mr.
Okay,
Bailey.
Barron County, will you, bring the accused up? You have a file on this here? Y'all have I guess I have it here. Is this, Lyons?
Yes, sir, Judge.
Commonwealth versus Lyons, is that correct?
Yes, sir. Hannah Lines.
Okay, Barron County, will you turn your camera on? Are you having dessert now, Mr. Bell? I see you're still chewing.
I got a peppermint, Judge.
Okay, well, that's okay.
Sometimes I get the shakes.
Yeah.
But it's about gone.
Okay, is Barron County on yet? Barron County, will you turn your camera on? You're up on the screen. Commonwealth versus Hannah Lyons. Yeah. Megan, if you're back there, could you call the jail or text the jail, tell them to turn their camera on?
I just spoke with them. They should be getting on right now.
Hmm? 24 CR 0002 Monroe Circuit Court meeting here in Cumberland County by agreement of the parties. Mr. Bell, do you have anyone over there at the turnkey or anyone you can call at the jails? Help us out here.
Judge, I'll be honest with you. They don't like me much at all, I don't think.
Okay, you don't have to say much. And that's understandable. I understand when they don't like it.
Oh, Vern, you. There they are.
There we go.
Can you hear me?
Yeah, I can hear you now.
Okay.
Commonwealth versus Hannah C. Line, 24 CR 0002 Monroe Circuit Court meeting by agreement in Cumberland County and via Zoom. State your name for the record, please.
Hannah Chloe Lyons,
What are the last four digits of your social security number, Ms. Lyons?
6857,
And what is your year of birth?
1997.
A motion has been made that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Do you understand what's going on here today? Is your mind clear?
Yes, sir.
Have you had the opportunity to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Are you fully informed about your case? Have you had time to look at the information?
Yes.
You have certain rights under Kentucky and United States Constitution. Before I can accept your plea, I need to know that you understand those rights. I will go over the rights and then I'll inquire if you have any question about it. If you have the right to remain silent, no one can make you say anything. You have a right to a trial by jury of your peers. You have a right to introduce evidence in your behalf and have subpoenas issued. Call witnesses you might want to have called. You have a right to cross-examine any witnesses against you. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges. If you were found guilty, you have a right to have an appeal in this matter, have counsel and funds provided if you are unable to do so. Do you understand those rights?
I do.
I'm waiving those rights and allowing the court to proceed.
Yes.
Now, this is a felony plea.
Yes, Your Honor.
And So I'm gonna ask you, are you guilty of doing the charges or doing the conduct that's charged in this amended indictment? Did you do those things there?
Yes, sir.
And then you realize that after entering a plea in this case to a felony, that you have any felonies in the future, that under persistent felony offender law, your sentence could be enhanced. Do you understand that?
Yes, sir.
And now I'm gonna call upon the Commonwealth to read the agreement, and I want you to listen very closely to this line to see if this is what you agree to. Counselor?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first offense, oxycodone, the defendant shall receive a sentence of 5 years, probated for 5 years supervised. The defendant shall enter and complete the Monroe Specialty Court. The defendant is currently incarcerated and has served 42 days in jail as of the entry of this plea. She shall remain incarcerated until the morning of specialty court orientation and shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence disposed of in accordance with laws of the Commonwealth and the holding agency.
Ma'am, is this what you agreed to?
Yes, Your Honor.
I will order a pre-sentence investigation report done by probation and parole. We will schedule sentencing. Megan, when's the next rule day over in Monroe County?
18.
18th?
Yes.
Okay. We will do April the 18th will be your sentencing, and then I guess you'll be evaluated by the drug court to see if you get voted into the drug court, and then it says that the morning of your orientation, assuming you'll get voted in. Has the drug court talked to you yet, ma'am?
Yes, Your Honor, they have.
Okay, well, they'll tell you what today is. On the morning that you receive your orientation, I'll sign an order letting you out, give you an opportunity to clean yourself up, make yourself presentable before you go up for the orientation, okay? Now,
Yes, sir.
court costs will be $200 and something probably, but at your sentencing, I'll get the exact amount. And if you need some time to pay that, then I'll consider that, Mr. Bell. You need to bring that to my attention.
Yes, sir.
Mr. Bell, is there any other thing that you need? I guess I need to hold this up and make sure that is your signature there on that. Is that correct?
Yes, that's right. That's my signature.
Okay, well, we will proceed.
The only thing I would ask, Judge, if you might consider letting her out. We had a diversion worked out on this last court date. She'd had a prior, and that's the reason we didn't get it through, so it's held her in jail longer. She does have a small child.
Well,
She's gonna live with her grandmother.
You can talk to the Commonwealth about that. The only thing I can do is go with the plea agreement. If the Commonwealth's agreeable, take a look at that. But, you know, we always hold people till they get through the drug court orientation. So if
Yes, sir.
there's a drug court, the orientation has to take place over there. So I think they'll probably have to do that. Okay, but talk to the Commonwealth about it, and if y'all can work something out, I'll take a look at it. Thank you.
All right, Judge, thank you.
When is orientation, Your Honor? Do you know that?
Contact with you. They'll be in contact with you too and tell you when
I'll
that is.
let you know, Hannah.
Okay, thank you.
Thank you very
Thank
much. Barron Detention Center, you are excused. Thank you very much. Now let's return to the case at hand here. In front of us, which is Commonwealth versus Thomas O'Donnell, 22 CR 00103. You want to call your next witness?
I will, Your Honor. Detective Burton.
Detective, please take a stand. And I'd like to limit the detective's testimony to this motion here first, and then we'll call him back when you talk about your other motion to suppress the statement. Okay, will you raise your right hand, Detective, swear the testimony about to give us the truth, the whole truth, nothing but the truth?
Yes, sir.
Sit there, identify yourself with whom you're employed in what capacity.
Detective B.J. Burton. I'm a general investigations detective with the Kentucky State Police, currently assigned to Post 15 in Columbia, Kentucky.
Mr. Stock.
Cumberland County, Kentucky, is in your jurisdiction.
Yes, sir.
Did you get a call about a body being discovered in Cumberland County? I think it's back to September of 2022.
Yes, sir.
And can you tell the court how that initially started? We're not going to go through every detail of your investigation, but just how you became involved in this case.
So we were contacted on September the 26th by initial call came in from the Cumberland County Sheriff's Department. It was in reference to they had located a deceased body at 3619 Glasgow Road, requested our assistance investigation.
Okay. And initially, what did you try to do, attempt to do when you became involved in the case?
So we became, actually prior to even getting to the scene, we were somewhat, aware that there was an individual that had been reported missing out of Tennessee. And, I think the Cumberland County Sheriff's Office, when I got to the scene, they had told us that they had tried to locate that individual, off from cell phone pings, the prior week, but hadn't been able to locate him. And then they were fairly certain when I got to the scene that the individual, Michael Harding, that they'd been trying to locate was the decedent inside of the house.
So there was a strong presumption that's who it was at that time.
Yes, sir.
Okay. And did the KSP take over the investigation when you arrived?
Yes, sir.
Okay. And was the scene secured?
Yes, sir.
Okay. And after you identified the victim, did you take certain steps trying to identify the perpetrator in this case?
Yes, sir.
And what was the general things that you did?
So pretty early on from my discussions with the sheriff, and then I made contact with the real estate company that had the two houses there at 3619 Glasgow Road for sale. It was pretty evident that the last person that made contact about the house had been the week prior when Michael Harding, the individual, the day he was reported missing. And then early on in phone conversations, it became apparent that he had most likely been lured to that location for the purpose of an HVAC service repair. So when we got there, Mr. Harding's truck was inside of a two-car garage there. Of course, the obvious indication is that, you know, HVAC service repair person doesn't show up and pull inside the garage and let the garage door down when they're going to work on heating and air. So that was the first thing that was really odd to me. So again, in that first hour or so that I was there at the scene, I asked the supervisor, made the determination that it would be best just to secure the scene for the entire night and see if the lab personnel from our lab could come down and process the truck there in the truck or in the garage without moving it, since it looked to me like it had been, it being in the garage with the garage door closed, that there was more likelihood that DNA or anything like that hadn't been destroyed because of rain or weather or sitting outside or anything like that.
Okay. What happened? So the truck remained in the garage.
Yes, sir.
And then what about the real estate lockbox? Did it remain on the door, or what did you all do with it?
To my knowledge, I think it remained on the door. I don't think we actually collected that day, but it was another detective that was there maintaining the scene after I left from the scene, probably an hour and a half, 2 hours into the investigation. And there was another detective that stayed there at the scene. And then later on the night, a trooper maintained scene security until the following day when the lab personnel could come down.
Now, every murder you work or potential homicide that you work, you don't involve the FBI, do you?
No, so that's correct.
Now, did you request assistance in this case?
Yes, sir, that's
Can you
correct.
tell the court how the FBI became involved in this case?
So after the first day of the investigation, we did several interviews that night, and then the following day, more interviews, and it became apparent that, or at least it appeared to me that the decedent had been lured to that scene, and then almost everything else related to the possible crime had occurred outside of Kentucky. In other words, the victim lived in Tennessee, was originally from California. But at that point, I'd made multiple attempts to contact Julie Harding. She wasn't responding to any calls. From the interviews that first night, it was apparent that the principal conflict going on in the victim's life was this ongoing disputed divorce between him and Julie Harding that involved a substantial amount of money and conflict over the property. So again, and I was also, by that time, I was aware of Julie Harding's position with the California Highway Patrol. So again, given all of those factors, we reached out to the FBI to ask for their assistance and see if they would be interested in opening a case on their own to take a federal case.
So at some point in time, you began working with FBI agents, is that correct?
Yes, sir.
And who would they have been?
I think it was actually the patrol lieutenant at post that had a contact with the FBI office in Bowling Green that reached out to him. But then I think it was on September the 28th when myself, one of the other detectives, and the detective sergeant actually met with Doug Johnson and Eric Stroud, which were two agents out of the Bowling Green office.
Okay. And what types of things did they assist you with, or, let me put it this way, when they first contacted you, they had an open investigation for themselves.
That's correct. The first meeting, they basically just said, and I explained to them what information I had so far. They did offer some assistance as to like explaining, things that might could be done with a cell phone, locational data, that sort of thing, but they didn't offer anything further than that, really. Basically, they told me that they would have to go back and talk to their supervisor as well as the U.S. Attorney's Office regarding any further involvement or whether they could open a case or that sort of thing.
Okay. Now, skipping everything else that was done and happened, at some point in time, KSP turned over the swabs and the evidence, the DNA swabs that was taken at the scene. Is that correct?
Yes, sir, that's correct.
And those items were collected by KSP personnel?
Yes, they were collected by our lab personnel that came
Okay.
down the following day.
Tell the court what led to those items being turned over to the FBI?
Okay, so I don't remember the specific date, but probably two weeks into the investigation, Agent Stroud and Agent Johnson, they advised me that they had got authorization, that they were opening an FBI case for a murder for hire case. And at that point, I asked them, I said, what do you want me to do with the evidence that I had, that we've collected? Do you want me to submit it to my lab, or do you all want to take it? And then it was determined that they wanted me to bring it to them, and so that they could submit it to their lab. And so that was what, I think it was the following day. I checked the majority of the evidence out of our evidence, and I drove it to Bowling Green to the FBI office and turned it over to Agent Stroud.
Did you believe that there was going to be a substantial likelihood or probability that they were going to keep the case and prosecute it at that time before you turned over the DNA evidence?
Yes, sir.
Okay. And is that something they informed you about?
Yes, sir. Every indication was that they was going to proceed with the investigation for a murder for hire case.
Okay. And so do you have the date that evidence was turned over to them?
I don't know if I have it in front of me. It would be on the KSP 41s, where I signed it over to Agent Stroud.
You can find that we have. Yeah, I haven't heard about the date. I'll do this 41 without the date.
Mr. South.
You have,
It's rushed back.
okay, thank you. So it looks like, according to this FBI form, that it was signed over October the 4th, 2022. I don't know if that was fresh.
That's probably correct. It should be on the KSP 41s, the date that I released it to Agent Stroud.
After the DNA evidence was signed over to the FBI, did you continue to assist and work on the case?
Yes, sir.
And what role were you playing at that time? What were you doing?
There had already been a number of search warrants and subpoenas that we had sent out, that the Kentucky State Police had sent out in regards to my homicide case that I had opened. And we were still waiting on some of those to come back. And then I continued forward investigating my case because I didn't know if at some point in the future, if they got to some point where they eliminated Julie Harding as a suspect in a murder for hire case, I felt like the case may come back on me because I would still have the homicide case open. And so basically I continued with my investigation, but we were sharing information back and forth as to they were taking steps as well.
Okay. And at some point in time, then you were notified that they weren't going to pursue the case federally. Is that correct?
Yeah, they've never really told me 100% for sure that they're not going to pursue the case, but obviously once Julie Harding committed suicide, it got to a point where they kind of the interest dropped off and,
Okay.
they gave every indication that they would no longer pursue federal charges.
Okay. And you didn't ask for the evidence back from the FBI lab, did you?
No, sir.
Did you ever have any communications with them,
I'm sorry.
with the FBI crime lab?
No, I never spoke to or communicated with the FBI
Okay.
lab.
Did you ever have any conversations after the evidence was turned over with Special Agent Johnson about the DNA evidence?
Other than when he notified me that, when he sent me, I think he actually sent me in an email, the DNA results that they had got back is the only conversations. I think maybe at one point, I had asked him about lab results, if he had gotten any lab results back, but there was never any communication about what was being tested or where it was at their lab. I just assumed that their lab was similar to ours and it would probably be a year or so before we got any results back.
Okay. And at some point in time then, was Thomas O'Donnell arrested? Did y'all come to the decision that he was going to be arrested?
Yes, sir.
And was he arrested on a state or a federal warrant?
It was on a state warrant.
And why was that?
So I got to a point in my investigation where I felt comfortable, like I had enough information to charge him with the homicide. At the same time, I think the FBI had reached a point in their investigation where they were interested in serving search warrants in California, and trying to get more information that way. So that was I guess that when we got to that point, that was the route we took, where that I was going to get an arrest warrant in state court for the homicide charge. And then they were going to serve additional search warrants related to their case in California. Again, all of it under the presumption that some point thereafter, they would also indict in federal court, both subjects, both Mr. O'Donnell as well as Ms.
Do
Hardy.
you recall the date Mr. O'Donnell was arrested in this case?
I think it was December the 7th, but I'd have to look back to make
And
sure.
that occurred in California, did it?
Yes, sir.
And was it within the next week that you found out that Julie Harden had possibly committed suicide?
Yes, sir. It was on the trip, actually on the plane on the way back from California.
Is when you found out about it?
Yes, sir.
After the arrest had occurred?
Yes, sir.
Okay. At any point in time, did it ever occur to you about the testing in this case that this might be consumed and might violate Kentucky law when you were conducting your investigation? Did that ever occur to you?
No, because it's never, when we submit stuff to our lab, it's never asked. They never call or, like we submit and then our lab personnel, I guess, knows the procedures as whether. it
They
can
know
be-
what the Kentucky statute is. what
Yes,
you're
sir.
saying.
Yes, sir. So I just assumed the FBI lab operated under the same standard, but nobody ever called me or asked me or told me or said anything about
Okay.
consumption.
Did you and Detective Special Agent Johnson enter into some kind of agreement where you would send this to the FBI lab so it could evade defense counsel testing?
No, sir. Absolutely not.
Okay. Just never occurred to you the way these circumstances arrived?
No, sir. Again, once I turned it over to them and they had their case, in my mind, it was
Yeah.
up to them to process it and do it per their standards.
Okay. How long have you been with, in law enforcement?
24 years.
And how many murder cases have you worked in the Commonwealth of Kentucky?
If I had to guess, probably 100 or so.
Okay. And you've probably had several trials, and,
Yes, sir.
okay. Has this ever been an issue in any of your cases before?
No, sir.
And you also said that if there's ever a problem, you'd be contacted by your state police lab about consumption?
Yes, sir. Anytime we've ever sent anything up there, if there's an issue or a question, they usually contact us to ask or clarify, but
Okay. So it's routine for you to have communication with your own lab?
yes, sir.
You never had any communication with the lab in Quantico, Virginia, have you?
Yeah, that's correct. Yes, sir.
Okay. Nothing further.
Afternoon.
Afternoon.
Okay, so Detective Burton, you said you did respond to 3619 Glasgow Road on September the 26th of 2022.
Yes, ma'am.
And that was the day that Michael Harding's body was discovered.
Yes, ma'am.
And can you kind of describe the property? Because there's two different homes on that property, is that right?
Yes, ma'am. So I'm not exactly sure how many acres there is or how large the property is, but there's two homes. There was like, kind of a nicer, more modern home. And then, right beside of it is kind of an older, smaller farmhouse. And then there was a large two-car garage
In between the two homes?
in between the two homes. Yes, ma'am.
Okay, and so when we're talking about the key box, that was on the nicer, larger home, not the small farmhouse?
Yes, ma'am.
Okay, and Michael Harding's body was discovered in the small farmhouse, correct?
Yes, ma'am.
All right, and you were the lead detective on the case?
Yes, ma'am.
All right. And on September 26th, you and Detective Debris started conducting interviews with witnesses.
Yes, ma'am.
You interviewed Alan Sewell,
Yes, ma'am.
Natasha Davis,
Yes, ma'am.
Paul Wilhelm,
Yes, ma'am.
and you said the crime scene response unit came to the scene and collected evidence. Did they come both on the 26th and the 27th, or just the 27th?
Just the 27th.
All right, and part of that collection included taking swabs from both of the homes and then the truck found in the garage.
Yes, I'm not for sure if they took any swabs from the smaller farmhouse or not, but I know they did from the truck and then obviously from the lockbox.
And the FBI was not present at the crime scene.
That's correct.
And then crime scene response unit released the swabs to Detective Debris on September 27th, the same day they took them.
Yes, ma'am.
May I approach, Judge?
So you have
For the
any
witness.
witness.
Yeah, sorry.
What is your approach?
This is an evidence release form. Okay, do you recognize that document?
Yes, ma'am.
Can you explain what it is?
So when our crime scene response unit, number one, they don't respond to the majority of scenes or the majority of cases we have. So it's kind of unusual to get them that they actually respond. But when they collect evidence, they don't actually submit it for testing. They collect it and turn it over to either the case officer or another detective that's there at the scene. So basically this is where they are releasing the evidence that they've collected to Detective Debris.
Okay, and they've listed, it looks like 23 items, but that's not 23 swabs, correct?
No, I would think that it would be more swabs. I'm sure some of those
So for instance.
collections are multiple swabs
Right.
or some of those items.
Person involved, I guess the lab examiner testified having swabs throughout the night, so I don't know where we're going with this.
I'm just trying to identify how many swabs were turned over to the state police judge.
Well, he probably knows what's on the form. I would doubt if he has.
Right.
Very much recollection unless it's been,
Okay, so from the form, you cannot tell the exact number of swabs that were released.
No, so like, for example, item 19, it just says swabs from driver door inside the handle, but it doesn't specify exactly how many swabs.
And how would swabs be packaged at that point when they're released to you?
Well, I wasn't present when these were collected or handed over to Detective Debris, but I mean, normally,
I'm just asking generally, Judge, how the lab, or I'm sorry, how the
All
techs
right,
package
go
the
ahead.
swabs.
I mean, normally when they hand them over to us, they're generally in an evidence envelope. They've already been packaged. There's a separate box. Most of the swabs that we use, there's a box. It's like in a flat, but it folds out. The swab goes in there and then the box goes into a separate manila envelope and then the envelope's sealed. And in the case of multiple swabs, you might have multiple manila envelopes in a larger envelope that would be labeled one evidence item.
And where were the swabs stored after they were turned over to the state police?
They were initially booked into evidence at Post 15 in Columbia.
Okay, and is that, you have a locked evidence room or where would they be?
Yes, ma'am.
Okay, And before becoming a state trooper, you had to go through training, right, to hold that position?
Yes, ma'am.
Okay, and one of the things you're trained on is how to collect and store evidence properly.
Yes, ma'am.
You're not trained on performing forensic DNA testing.
That's correct.
And are you able to see DNA with the naked eye?
No, ma'am.
So when CSRU provided the swabs, there was no way for you to know how much DNA would have been on them.
That's correct.
You've had DNA testing performed in other cases,
Yes, ma'am.
and I think you said you've worked 100 murders.
That's an estimate over the years, yes, ma'am.
So in dealing with DNA testing in your other cases, are you familiar with reading lab reports?
Yes, ma'am.
And you're aware that sometimes labs can consume the entire samples when they're doing DNA testing?
Yes, ma'am.
And when KSP sends items to the state lab, you use a standard request for evidence examination form, don't you?
Yes, ma'am.
May I approach the witness, Judge?
Sure.
Judge, I have forms. Okay, this is for a different item in this case, but is this the form that you would usually use when you're submitting evidence to the lab?
Yes, ma'am. It's KSB 26.
Okay, and nowhere on this form is there a box that you can check that permits consumptive testing?
That's correct.
All right, so if you send samples to the state lab, I think you testified earlier, the lab contacts you or the prosecutor about consuming samples if there's an issue.
If there's a problem or issue, yes, ma'am.
Right, but officers in Kentucky don't make that decision.
I've never been, I don't think the lab's ever contacted me and asked me about consuming an entire sample, so I don't.
Okay, and you're also, in your training as a trooper, you're trained on the different laws of Kentucky.
Yes, ma'am.
You're required to be familiar with those laws.
Yes, ma'am.
And are you familiar with the statute for tampering with physical evidence?
Tampering with physical evidence, yes, ma'am.
And you're aware that that statute includes the destruction of evidence?
Yes, ma'am.
All right, so after
Are
detective
you
debris.
you're talking about some statute other than 524-140, right?
Yeah, I'm asking him generally about the tampering statute. Okay, so after detective debris received the swabs on September the 27th of 2022, they were not sent to the KSP lab.
That's correct.
They were stored in your evidence room
Yes, ma'am.
and nothing was done with them at that point.
That's correct.
And you said that you chose to involve the FBI in the investigation pretty quickly because you realized there was a multi-state component to the case.
Yes, ma'am.
So do you know what date you initially reached out to the FBI?
The first time we met with them was on the 28th. Almost immediately, the issue I ran into was like, number one, I probably needed to do a search warrant at the victim's home, which was in Tennessee. So from the get-go, I was dealing with jurisdictional issues.
Okay. So the FBI has different resources and they're able to do some of those things that you can't do because of
Yes.
jurisdiction.
Jurisdictional issues, yes, ma'am.
And I think you testified that when you met with them on September the 28th, the only assistance they offered at that point was some advice about cell phone records.
Correct.
And they told you they'd have to get back to you because they had to talk to their supervisor.
Yes, ma'am.
And that was September the 28th.
Yes, ma'am.
All right, and then on September the 29th, you, Detective Debris, Agent Johnson, and Agent Stroud traveled to Tennessee to conduct interviews of Sue Estep and Julie Harding, right?
No, on the 29th, I had told them in the meeting on the 28th that I felt like I needed to do a search warrant at the victim's house. And at that point, we had already reached out to the Clay County, Tennessee Sheriff's Office about doing a search warrant. And I explained all this and told this to them in our meeting.
I need to take a brief break. I'll be right back. We'll go in recess.
Did you all look at these? Which one you want? I don't like that, but we might have to do this stuff. I know I was gonna help them figure out things.
Hey, all this. I'm the building one.
So that's one part. It's not, it's
Bad. People work in this. And I'm also, why would I say no? And it's okay, we will always look for that. We just.
I'll be one of those. I'll get somebody. Makes you grand. Yeah. That's the thing about. Yeah. I don't know.
Let's go back on the record. I want to refresh the witness system.
Yes, Judge. So I was asking if you, Detective Debris, Agent Johnson, and Agent Stroud were at Julie Harding's neighbor's residence on September the 29th of 22.
Yeah, yes, ma'am. Would you like me to explain?
Did you interview Susie Step while you were there?
Yes, ma'am.
And all four of you were present?
Yes, ma'am.
And you also spoke with Ms. Harding for briefly?
Yes, ma'am.
Okay, so let's back up a little bit. I know you said you involved the FBI because of the multi-state component. So when you reached out to the FBI, they were not investigating Michael Harding's murder, right?
That's, again, they told me that they would have to talk to the U.S. Attorney's Office as well as their supervisors as far as opening the case. So no, on the 28th, not initially.
You made them aware of the case.
Yes, ma'am.
And do the FBI and Kentucky law enforcement work with each other on investigations regularly?
I wouldn't describe it as regularly. I mean, occasionally, or at least in my line of work as general investigation detective.
Have you been involved in cooperative investigations before with the FBI?
Yes, ma'am.
All right. And after those operations, it's possible that the person or the suspect is charged only in state court, right?
Yes, the cases I've had in the past where I worked in conjunction with the FBI, though, the majority of the time they've been charged in federal court.
Okay. So they could be charged in federal court. They could also be end up in state court. Is that fair?
This is kind of the exception. The majority of the time that I've had cases with them, it ended up in federal court.
Well, you wouldn't have opened a case if you didn't think there could be state charges, right?
That's correct.
Okay, so we discussed the 29th. You and the agents were out in Tennessee on September 29th. And then as the investigation continued, as you said, KSP continued to investigate and collect evidence, and the FBI began investigating as well.
Yes, ma'am.
So for instance, and you and the FBI were freely sharing information.
Yes, ma'am.
So in October of 2022, you provided copies of surveillance in Burkesville to the FBI.
Yes, ma'am.
And on November 22nd, 22, you participated in a case briefing with the agents at the Bowling Green FBI office.
Yes, ma'am.
And on more than one occasion, the federal agents obtained hotel records or casino records on Mr. O'Donnell and provided those to you.
Yes, ma'am.
Okay. They also ran searches for hits on the LPR system for Mr. O'Donnell's license plate nationwide, right?
The majority of the LPRs actually came from me, but there was some from the FBI.
And they shared those with you?
Yes, ma'am.
And you shared yours with them?
Yes, ma'am.
Okay. And you said the FBI's interest in this case was that it was a potential murder for hire,
Yes, ma'am.
and you were investigating the case as a murder for hire as well.
My principal case was a homicide. And again, the potential, it could have turned into a murder for hire case in state court as well. But again, the jurisdictional issues, it seemed that the majority of planning took place outside of Kentucky.
So you were investigating under the belief that it was potentially a murder for hire.
Yes, ma'am.
All right. And on October 4th, 2022, you didn't have a suspect identified.
On October the 4th,
Yes.
I don't recall. I don't know if you would have called him a suspect at that point. I think we already had a person of interest, but from the phone records, from Julie Harding's phone records.
And you didn't have any evidence from your investigation or the FBI's were showing someone being paid a large amount of money prior to the murder?
No,
At that.
no, ma'am.
And on October 4th, you delivered the swabs from the crime scene to the FBI.
Yes, ma'am.
So you had them in the KSP had them in their possession from September 27th to October 4th
Yes, ma'am.
and did not send them to the lab for testing.
That's correct.
Had you discussed the testing, the DNA testing with the Commonwealth's office at that point?
No, ma'am.
Criminal procedures.
And you said you delivered the swabs to the FBI because that's what Agent Johnson wanted you to do?
When they informed me that they had got authorization to open an FBI case and we discussed the evidence and I asked if they wanted me to turn the evidence over to them or send it to my lab. And the discussion was it'd be better to turn it over to them.
Okay. And at that point, had federal charges been filed?
No, ma'am.
What about state charges?
No, ma'am.
So both investigations were still going on, federal and state.
Yes, ma'am.
Had state charges been filed at that time?
No, not October the 4th was just,
When you turned this.
there hadn't been any charges filed in either court.
Excuse me for interrupting. I just.
No, that's fine. Okay, so when Agent Johnson submitted his laboratory examination request, did he send you copies of those?
No, ma'am.
So I think you testified earlier that you just assumed that the FBI lab would follow the correct procedures as far as Kentucky law.
Yeah, I don't know what I've never dealt with the FBI lab as far as like me personally requesting evidence processing. So I mean, I don't know what their protocol is. So, I mean, I assumed like our lab, if there was a problem or an issue that somebody would call me or contact me.
But you were aware that Kentucky law prohibits the destruction of evidence.
Well, you're asking him for a legal conclusion, and I want to have a discussion about theory on this later. He's told you what he was aware of, so I'll sustain the objection.
You were aware of the statute in Kentucky that prohibits consumptive testing without a court order?
Say that again?
I asked if he was aware of the Kentucky statute prohibiting consumptive testing without court order.
Okay, right now would be a good time to have a hearing about that. If you want, I think that's a good question to ask, but when you finish him, I'd like for us to go over the statute so that we can have the proper examination of him on that. So I'm gonna call a recess in his testimony and ask, and let us all, are you talking about 524-140?
Yes.
Okay, in order to properly, you can take a seat back there. You know, you keep making that assertion that that's what that statute says, and I want us to look over that statute because things that have happened today, informationally, as far as the context and the timing of charges, I didn't know where charges had been made before this testing had taken place or before or after, but his testimony was that there weren't any charges in place in state court or in federal court at the time.
That was the date he turned the swabs over,
Yeah.
not the date of the testing.
Well, that's what I meant today. He turned, well, the testing couldn't happen until he turned the swab, so we're good. Okay, so you know, When was, the testing was done after the charges or before? the
No, Your
charges?
Honor, it was three of the items 10 and 11 and 18 were done in November. He wasn't arrested until December the 7th. Items 3, Mr. Fletcher testified there was 3 rounds of testing, with the last being complete March of the next year.
The
So-
swabs.
The swabs, yes, all this is swabs. So only one of the items was consumed after Mr. O'Donnell was arrested.
Okay. And had he been arraigned yet?
Yes.
Yes.
Now, let's look at 524-140. And if you got it in front of you there, Mr. Stock,
I don't know.
I can get you a copy of it there if you.
I'll pull it up.
Now, it appears that 524-140 talks about the legislature anticipating that consumption could take place in testing. That's the subsection 5 of the statute.
Yeah, Judge, I'm sorry, I'm looking for.
Okay, we'll give you plenty of time. And essentially, this statute was passed to protect DNA samples, especially in rape kits and things like that, and to make sure people could be exonerated where there were samples that maybe testing in the future would have something to do with. But help illuminate me here on what section of it you're relying upon that says that evidence should be excluded.
This statute doesn't say the evidence should be excluded. This statute says that violating this statute by destroying the evidence is a Class D felony. The case law says it should be excluded.
I would disagree with that.
I don't say,
It's
this,
specifically in there.
this statute says under subsection 5, it talks about where there's liability for consumption or destruction. If these exceptions are met, that it's not a violation of this statute. Is that what subsection 5 says?
Yes.
So, and it goes down through there and it talks about the order of the court, to get an order of the court. Well, when you're doing criminal investigations, you don't have a court to seek an order from. You know, if they got blood tests or blood swabs or whatever, whether it's the state, and this talks about Kentucky State Police Laboratory, what court would they go to? They don't know whether there's going to be any charges ever filed. They don't know where it's. I mean, how do you think that works? Show me in the statute. Let's read down through the statute. Is there anything other than subsection 5 that deals with the consumption or destruction of evidence?
Yeah, I think subsection 5B.
Well, we're gonna read down through all of 5.
Okay.
Here, okay? It is recognized by the General Assembly that DNA evidence, laboratory testing and analysis procedures consumes and destroys a portion or may destroy all the evidence if the sample is small. The consuming and destruction of evidence during the laboratory analysis process shall not result in liability for its consumption or destruction if the following conditions are met. Number 1, the Kentucky Department of State Police Laboratory uses a method testing or analysis which preserves as much of the biological material or other evidence tested or analyzed as possible. Or B, the Kentucky Department of State Laboratory knows or reasonably believes that the entire sample of evidence to be tested and analyzed, that the laboratory prior to testing or analysis notifies in writing the court which ordered the testing and analysis and counts for all parties. Now, and then it sets up the things. Now, during an investigation, this testing has not been ordered.
Your Honor, that's not the subsection that my motion's referring
Okay,
to.
well, I'm going through the whole subsection, okay? Now, what subsection are you going by?
I'm going by section 2, which is quoted in my motion.
Yeah, well, I know. Okay, subsection 2, okay.
If I could answer the court's earlier question, officers come to the court and get orders during investigations all the time. They get subpoenas issued regularly without having charges filed. They could come to the court and ask for permission to consume testing.
I've been practicing law for 45 years. I'm on bench on 13 years, and I've never seen the court involved in issuing any orders about any testing of any materials at the Kentucky State Police Lab or any other lab during an investigatory situation. But let's go back to subsection 2, okay? Says no item about, that's what you're, no item of biological evidence gathered by law enforcement, prosecutorial defense shall be subject, that may be subject to DNA evidence, testing or analysis in order to assist federal, state, or local criminal justice and law enforcement agency within or outside the Commonwealth in identification, detection, or exclusions of individuals who are subject to investigation, prosecution, or to confirm guilt or innocence of criminal offense shall be disposed of prior to the criminal trial unless the evidence is over 50 years. The evidence has been in custody less than 10 years. The prosecution has determined that the defendant will not be tried for the criminal offense, and the prosecution has made a motion before the court in which the case would have been tried to destroy the evidence. Now, you say that you think that's applicable to consuming of evidence, is that destruction of evidence and consuming? Because it appears, the reason I read the other part of the statute, it appears to me that this statute differentiates between consuming and destroying evidence.
I think subsection 2 specifically applies to investigation of suspects and people that may be potentially charged. It also applies to state and federal law enforcement.
It does, but it talks about destruction of evidence. It doesn't talk
Yes.
about consumption. And over the reason I read subsection 6, it talks about the Kentucky State Police Laboratory. When it's going to consume all of it, she'll have certain duties or may be exempt from any liability.
But the Kentucky State Police Laboratory is not involved in this case. It's the federal
Exactly,
laboratory.
exactly, they're not.
So subsection 2.
So,
applies,
but
not
if,
subsection 5.
so they're not involved. So what you're saying is if the FBI sends something to their lab and it's consumed, it doesn't matter whether it's a joint investigation or not a joint investigation. The results of that test could never be used in the Commonwealth of Kentucky. Are you saying that?
No.
What would be the circumstance if the FBI was involved in this same case that the Kentucky State Police had not been involved in it? They came up with this evidence on their own, the swab and the tests that they took on the location here in Cumberland County. They sent them to the FBI lab. They consumed everything in the FBI lab, decided they didn't want to prosecute the case, that it was better prosecuted in state court. They sent it back down to the Commonwealth attorney. You say he couldn't use it because it'd been consumed under the statute?
It depends if there was a joint investigation.
No, I'm not, I'm saying there wasn't a joint. My hypothetical
There was
situation is
not?
there was not a joint
Then
investigation.
I think the case law says it can be used.
What case is that?
Elkins, Basham, I don't know what else I cited in my motion, but I can submit them all to the court. They say if there's a separate investigation, a separate federal investigation, most of these cases deal with wiretap orders.
Yeah.
And so it's, the state was investigating a person for one crime. The feds were already, or separately, no communication, already investigating
Does
that
it say
same
no
person.
communication?
That's
Okay.
what the cases he did.
I didn't see that in the case, but
And
I'll
they
look
can
at it.
then give, once they found out, like, in some of the wiretap cases, the federal investigators figured out that the state was investigating the same person. They then gave them some information they got through a wiretap, and the state authorities were allowed to use it because it was a completely separate independent investigation. So even though it violated Kentucky law that didn't allow wiretapping, they still allowed it to be admitted because there was a completely independent investigation. So the most important question is whether this was a joint investigation or a completely
Well,
independent.
now, do you have a case on consumption of evidence? You're talking about a wiretap. I'm talking about consumption of biological or DNA evidence in a case that talks about a joint investigation. That's a difference.
The joint
Yeah.
investigation
You
line of
see what I'm
cases,
saying? I'm asking you a specific question.
I do not have one I do not have a case that's specifically about a joint investigation and the consumption of DNA evidence.
I haven't found one either.
I don't
You
think there
found
is
one?
No, there's not, Your Honor, and I think the Teague case is more relevant to this case, but I think Ms. Zurcher is being misleading when she talks about the Basham case, because the Basham case specifically says when there is collusion between the federal and state, and they're using collusion as a pejorative term, that it's bad. As an agreement between two or more persons to defraud a person or his rights by forms of a law or to obtain an object forbidden by law. That's what Basham stands for. They said if the state had used the federal authorities to conduct this illegal wiretap and we got it anyway.
Those are wiretaps.
That's right. And it's
They're all-
still talking about bad
cases on
faith.
This are wiretaps and things,
Yeah.
and it has very little to do with biological DNA sort of things where it was going to be consumed.
Yeah.
I disagree, Judge. I think it's
Well, I
analogous.
know you do, or you wouldn't be here. You would
Right,
disagree with that conclusion because that destroys your motions. But tell me why you disagree.
because
Alice.
the reasoning is the same. The reasoning is about evidence obtained by federal authorities that is illegal, obtained or used in a way that's illegal in the state courts, and whether or not that evidence should be excluded under the exclusionary rule. That is the exact circumstance.
Okay, well, now here's the thing about it. This evidence here that, you're saying it would be illegally used. The DNA evidence would be illegally used because of subsection 2. And the only reason you say that is because it was tested by the state police lab instead of wasn't tested by the state police lab, but by the feds. You're saying that even though subsection 5 says all the circumstances in which the Kentucky Department of State Police might avoid any penalty for doing that, doesn't negate the fact that it would not be admissible under subsection 2 if they consumed it. Let's say the officer had taken the swabs that they got from Mr. O'Connell's inside his cheek, sent those swabs to Kentucky State Police, and all the testing had been done there, and they consumed it. You'd still say it wasn't admissible, correct?
It clearly would not be admissible.
Well, I don't know. It's clearly not. I'll decide whether it's clearly or not, but so it doesn't matter with you where the feds were doing it or not. You'd say that even if the state did it, especially if the state did it, in your opinion, it would not be admissible.
It matters that there was no court order in effect. That's what matters. It's not about which lab. The issue is that Agent Johnson is the one that decided that they could destroy all of the evidence
They
that,
didn't destroy, they consumed it.
That
Okay,
destroyed it, Judge.
Well, there's a difference between destroying and consuming, in my opinion, but now let's go back to subsection 2 of 524(1). How would people ever get any DNA evidence compared? How would you do that? In other words, if you had any DNA evidence that was ever going to be consumed, it's your position that you'd have to go to a court where the charge might potentially be filed, to the circuit, where it might potentially be filed if you had any evidence that was going to be consumed, like DNA. And no case has been opened, nobody's been identified as a defendant. You just file a motion with the court saying this is going to be consumed. Is that correct? There's no defendant yet.
the Commonwealth attorney could notify the court, yes.
But there's no defendant yet.
Doesn't
So
matter.
the state police, every time they get any kind of test that they're gonna consume at their lab, the lab technician calls the detective calls the Commonwealth attorney. We don't have enough information yet to charge anybody, but we want the judge to sign an order to say we can consume all this DNA testimony, this DNA material in the test. That's how it works.
Or as Mr. Fletcher testified earlier, the lab would just test some of the swabs, not all
Well,
of the
he said that
swabs.
they couldn't test all of them and get enough DNA out of them.
That wasn't his testimony, Judge.
That's what I heard him say, that he got all of it because they couldn't determine how much DNA was gonna be on any of them, so they put it all together to maximize the amount of DNA they would get.
Right.
They still
So
only
how
got
would
a
he know
fraction.
that without doing that?
He wouldn't, but he testified that if Agent Johnson had marked, do not consume or consult me before you consume, they would have tested less of the swabs and preserved them,
No,
which would have complied.
I think he said that they wouldn't have tested them at all, that he'd called the officer back and said, what's the deal here? You said we can't consume them. So what do you have to say?
Well, this is a little bit complicated, but if you look at 524-140, nowhere in there is there a remedy that says that this testing has to be excluded if this procedure is not followed that I read. And then if you look at a case that's rendered by the Kentucky Supreme Court in November of 2018, Commonwealth versus Teague, 600 Southwest 2nd, 3rd, 218, they address this issue. In this case, you had a defendant that post-conviction, the detective destroys 31 out of 38 lab samples because he's cleaning up his evidence locker, probably. And this matter comes back before the court on retrial. And they look at 524-140 subsection 3, but they look at it as far as the exclusionary rule, they look at it under due process grounds. And in order to exclude this evidence, they find that due process of the defendant had to be violated. And they set out guidance in head note 10 and 11 as to how to exclude this evidence. And the first requirement is they have to show that the state, that is the detective and the FBI agent, acted in bad faith.
Well, let me stop you there though. All these decisions that you're talking about here.
Yeah.
Are all taking place after a defendant was identified,
Yeah.
a case was tried, and
Yes.
then evidence was destroyed.
Yeah.
This all takes place in an investigatory situation, and I just do not believe that this statute was intended to paralyze every investigation that happens in the state of Kentucky where they have potential DNA evidence, where they know or don't know they have it. So what they're saying is everything that goes to the lab immediately turns a red light on. We're going to consume all of it. They call a police officer and say, you've got to go to circuit court and such and so. There's no defendant. There's nobody to set up, and there's no adversarial proceeding.
And that's just like what you were saying in your hypothetical. If the Commonwealth had never been involved in this, if the FBI took this case and then decided they weren't going to prosecute it and dumped it in the state's lap, and this evidence had already been consumed, I agree. This statute doesn't say it has to be excluded at trial. It says here's the proper procedure to test it, but it doesn't give a remedy.
Well,
That's true.
my point is this was in an investigatory situation when these swabs were taken and they were submitted. And then once someone was identified, they take a swab on the person that was identified as the potential subject and send it in. That his swab was replaceable. These other swabs to test them had to be consumed. So there would have been no way to identify his swab and their swab until after he charged. What if they didn't have enough evidence? And it appears to me they didn't have enough evidence to charge. Had he been charged when his swab, he had been indicted? When his swab was
Yes,
taken?
he had been charged through district court on an arrest warrant when his swab was taken. He hadn't been indicted, I don't believe.
Okay, what do you have to say?
Judge, I'm going to ask to brief the issue at the end of the hearing so that I can lay
Well,
out.
I'm
my
not
argument.
gonna make a ruling on it now. I'm just
Okay.
doing this to help me put in context. The reason I want to talk about this is I can't hardly think about this in context unless I understand what your objection to this is. You understand what I'm saying? When I'm listening to this evidence, I'm trying to fit it into the scheme. And quite frankly, 524-140 is like every other great piece of legislation that's ever been written. It cannot anticipate everything that might happen out in the world. And so no piece of legislation can do that. Now, you have another, you want to put this witness back on the
She
stand and
was
continue?
cross-examination.
Yes.
Okay, well, you want to come back up and continue. You're still under oath.
Yes, sir.
Okay, so you said that, I think I asked, I'm not sure if you answered. Did Agent Johnson send you copies of the laboratory examination requests?
No, ma'am. That, not until the first time I saw those is when the lab results, I think he emailed me the lab results. And that's the first time I seen them.
Okay, so Agent Johnson did that without your involvement?
Yes, ma'am, that's correct.
Okay, and on December 7th of 22, you applied for an arrest warrant for Mr. O'Donnell in Cumberland County.
I'm sorry, could you repeat that?
On December 7th of 2022, you applied for an arrest warrant for Mr. O'Donnell in Cumberland County.
Yes, I think I think it was actually Detective Debris that ended up getting the arrest warrant.
Okay, was that done on December 7th?
I think so.
And as of that date, had your investigation uncovered evidence of Mr. O'Donnell receiving money or other valuables from Ms. Harding?
No, ma'am.
And the FBI did not obtain an arrest warrant for Mr. O'Donnell?
No, ma'am.
And you and Agent Johnson planned together the arrest of Mr. O'Donnell at the Sacramento airport on December the 8th, right?
They were at a point in their investigation where they wanted to serve search warrants at Julie Harding's residence, Mr. O'Donnell's residence, as well as his vehicle. And in conjunction, I was at a point I felt comfortable charging him with a homicide. So yes, in conjunction, we.
Right. I mean, the FBI conducted surveillance of the airport watching for Mr. O'Donnell so you could arrest him on a Kentucky warrant, didn't they?
Yes, ma'am.
And he was arrested at Sacramento airport
Yes, ma'am.
and then interviewed.
Yes, ma'am.
And you were present during the interview, and so were FBI agents, or Agent Johnson at least.
Yes, ma'am.
You asked questions during the interview?
Yes, ma'am.
Did Agent Johnson?
Yes, ma'am.
All right, and that was the date that the buccal swab was taken from Mr. O'Donnell.
Yes, ma'am.
And that was taken pursuant to a federal search warrant.
Yes, ma'am.
All right, and then his person was also searched pursuant to that federal warrant.
Yes, ma'am.
But when Mr. O'Donnell asked you what is a buccal swab, you explained the procedure to him, right?
Yeah, I probably did. I don't recall specifically.
Let me ask you, could you inquire at the date the swabs were taken off of Mr. Had the test already been done on the other material by the federal lab, FBI lab at that time?
They had consumed 10, 11, and 18 in
Had already been
November,
consumed before they ever took the test on him,
but they
right?
had not consumed item 3 until March of 23.
Item 3 was what they took off of the defendant.
No, item 3 is from the crime scene.
It was the door handle on the truck.
It's from the victim's truck.
It's the 7 swabs inside the door.
Yes. A
They'd
victim's truck.
already done the steering wheel and the key lock.
Yes, those were consumed in November. They did the testing on the other swabs from the door in March of 23. So 4 months after Mr. O'Donnell's arrest. Okay, and you also explained to Mr. O'Donnell that he was going to be extradited to Kentucky and
Yes, ma'am.
housed in either Adair or Barron County
Yes, ma'am.
on Cumberland County charges.
Yes, ma'am.
No federal charges were filed at that time.
That's correct.
No federal charges have been filed even now.
That's correct.
All right. And at any point in time, did the Quantico lab reach out to you and ask permission to consume the samples?
No, ma'am.
No further questions.
You don't have any further questions? We'll reserve this witness. You'll be called back tomorrow at 9 a.m. Do you have any other testimony today?
I just, when we do the, I guess you want to take up, I guess, Agent Johnson before we do the suppression motions in the morning.
I'd like to.
Yeah, that's the only reason, Mr. Burton.
He'll have to come back tomorrow regardless, because he'll be testifying on the suppression motion.
That way sequentially we'll have it on the record. That way, okay?
Okay.
Okay, thank you. Is there anything else to be heard today?
No, we'll do that tomorrow. Yeah, we'll, nothing else as far as the motion to exclude until the morning.
Okay, we'll recess until 9 a.m. Correct. You know, I think